afternoon. Today, Eastern European Dispute Resolution Forum presents Quick and Honest interview with Anastasia Bondarenko, Managing Director at Vannin Capital, one of the leading legal finance providers servicing this growing global market. Anastasia joined Vannin from 3 Crowns previously worked with the international arbitration teams at Freshfields and Defendants. My name is Olena Perepelynska. I'm a member of the organizing committee of Eastern European Dispute Resolution Forum, and the topic of our today's interview is monetizing legal assets. And our first question to Anastasia: when we're talking about monetizing legal assets, what we're talking about?
First of all, thank you very much, Alena, and thank you to the Eastern European Dispute Resolution Forum for conducting this interview. I'm delighted to be speaking today. When we talk about monetizing legal assets, what we're talking about is deriving monetary value from legal assets, either by bringing a claim which otherwise would not have been brought by resorting to third-party funding at zero risk and at zero cost, thereby generating a return which would otherwise not have been generated, or by accelerating the monetization of an award by deriving immediate monetary value from an award as opposed to incurring further costs and spending more time trying to enforce it, or by pulling forward cash flows from future dispute recoveries in the context of a corporate disputes portfolio funding.
And what is third-party funding?
Third-party funding is a financing tool used in the pursuit of litigation and arbitration claims. It's essentially a simple financing arrangement whereby the funder assesses a claim in order to determine whether it fits within the parameters of its funding criteria and agrees to finance or fund a party's legal costs and expenses in accordance with an agreed budget. And all of this is provided on a non-recourse basis. So what that means is if the claim is unsuccessful, the client does not reimburse the funder, and the funder writes off its investment. If the claim is successful, then the funder is reimbursed its investment and is entitled to a return in accordance with pre-agreed terms, which are negotiated and reflected in a tripartite funding agreement between the funder, the client, and the client's lawyers.
How is it different from a loan?
So what makes third-party funding different from a loan or any other recourse financing is the non-recourse, is the fact that it's non-recourse. So the client only has to pay money in terms of reimbursing the funder or paying a return on the funder's investment only out of proceeds it actually recovers from the dispute in question.
What do third-party funders look for when deciding whether or not to fund a case?
So when we decide whether or not to pursue a funding opportunity, we have a multi-level due diligence process. The first thing we look at are the financial aspects of an opportunity, including quantum, the budget, and the ratio between the two. When assessing quantum, we take, for the purposes of our analysis, we take a conservative view of quantum in that we will retain the documented quantum figure, taking into account relevant jurisprudence in order to assess which valuation method a tribunal is most likely to apply in a given situation. So for example, if we're talking about an expropriation of a greenfield project, what we're going to look at are documented sunk costs. If we're talking about the expropriation of a going concern, we will look at documented historical cash flows for a claim that's neither overly speculative nor overly optimistic. Then we look at the budget, and what we look for, we ask to be provided with a detailed budget, which is broken down by cost element, so legal fees, expert fees, tribunal fees, disbursements, and so on and so forth, and broken down by phase of the proceedings. And our strong preference is to negotiate a realistic budget at the outset and stick to it, as opposed to trying to fit into a very tight budget, which will have to get increased throughout the life of the case. Once we've assessed both of these elements, we will look for a 1-to-10 ratio between the budget and the quantum. And this is there to protect the client. Essentially, it ensures that when the claimant recovers less than they claim, which is more often the case than not, the funder has factored this into its assessment, and the client will not see the funder fully paid, the lawyers fully paid, and very little money left at the end for it. Once we have gotten comfortable on the financial aspects, we then look at enforcement. And what we look at is a clear path to enforceability of an award. So we will look for any potential enforcement hurdles. We will look for strategies to overcome these hurdles. We will assess the timing of recovery and the likely extent of recovery. In order to do that, we will take into consideration who is the respondent, what is the respondent's history of complying with adverse awards, what is the respondent's ability to pay an adverse award. In the case of a sovereign, do they have a pot of money set aside in their state budget for the settlement of adverse awards? And what are likely enforcement targets should the respondent not pay voluntarily? And then we look at the jurisdiction and the merits. And what we're looking for is at least a 60% chance of success on jurisdiction and merits. And of course, we're looking to work, we're looking for cases that are conducted under the auspices of a reputable arbitral institution, which have an arbitration, are seated in an arbitration-friendly jurisdiction and are governed by an arbitration-friendly law. And then we will also look and consider the actors involved in the dispute. So we would have already assessed the respondent, but we will also look at the claimant and their background. And we will also take into consideration the legal team, because we want to work with top-tier talent and the best experts suited for this particular case and any specificities that it may have, because that maximizes the chances of success.
What are the various types of funding?
So the traditional model of funding is single case funding, which is what we're discussing previously. Vannin assesses a case and agrees to pay parties legal fees and expenses in accordance with an agreed budget and on a non-recourse basis. You also have award acquisition, whereby we acquire either a stake in an award or an award, and you also have corporate portfolio funding.
How does portfolio funding work?
We provide funding against a portfolio of cases as opposed to a single case, and this enables us to hedge our risk. And what you see is, because our return is paid from the proceeds of all of the cases, you have successful cases subsidizing unsuccessful cases, and this diversified risk enables us to offer lower pricing. It also enables us to consider financing cases which we would not finance, which would not fit within our funding criteria on a single case basis.
How do you price award acquisition?
The structure and the pricing of an award acquisition will very much depend on the given award and where we are in the proceedings. So is this an award that has been recognized at the seat? Is this an award that has been through, in the case of an exit award, is this an award that has been through the annulment process, or has the time period for either challenging or has the time process for challenging an award expired? We will also look at how much is enforcement likely to cost? How long is it likely to take? What is the likely extent of recovery? What is the potential for settlement? And all of these factors will drive the price of an award.
Can you fund defendants?
Whilst funding is typically used by claimants, it can be an interesting proposition in the context of defendants as well. One can imagine, for example, a scenario where the defendant, the respondent, has a very strong counterclaim, or in the context of a portfolio, and Vannin's return will be correlated to what constitutes a success in a given case.
Who are the users of third-party funding?
So historically, funding was mostly used by impecunious clients, and the market has now evolved, and what we're seeing is well-capitalized corporates resorting to third-party funding who now see it as a tool as a tool in their suite of options in order to manage litigation risk and litigation costs. And indeed, in certain circumstances, a claim can be seen as an asset rather than as a liability. We're also seeing increased interest from law firms, both in litigation and arbitration, who are exploring third-party funding in order as a way to provide their clients with more advantageous fee structures as a marketing tool, and to share both the risk and the upside of contingency fee agreements with the funder.
What are the benefits of third-party funding?
Well, the transaction is non-recourse. So if the claim fails to generate proceeds, the funder is not reimbursed. There's also the risk shifting element. The client is able to shift the entirety of both the litigation and the collection risk onto the shoulders of the funder. Third-party funding also enables clients to pursue claims they would otherwise not have pursued at zero risk and at zero cost, thereby, as we had discussed earlier, enabling them to generate a return that perhaps would not have been generated were it not for the use of third-party funding. Funding also allows companies to preserve legal budgets and drive profitability more widely by diverting funds away from legal costs into core business activities, which will generate profit and produce a higher return on the capital employed, thereby increasing profitability and potentially market value of the business. Third-party funding also confirms the strength of the case. The scrupulous and extensive due diligence process of a funder enables the client and the client's legal team to really stress test the strengths and weaknesses of their factual and legal arguments. Third-party funding can also facilitate settlement. The fact that a well-reputed, well-capitalized funder who is known for funding only meritorious claims is backing a claim can send a very strong message to the opposing party, both in terms of the strength of their own case and in terms of the fact that they can no longer resort to procedural tactics in an attempt to bleed the claimant dry and force them to capitulate for reasons that are not tied to the merits of the actual dispute. And another benefit is the additional support that can be provided by having an experienced funder involved in the dispute resolution process. So we operate at the heart of the global disputes industry, and both because of the experience that the members of our investment team have in international arbitration in their previous careers as counsel, and the network of relationships that we have with various law firms and experts, we're able to really support the client in terms of providing advice when solicited or providing input when asked to do so, and also being able to help in building the best legal team to defend or pursue a claim.
What is the case selection process?
So before committing to fund a claim, we engage in a multi-level due diligence process. The first level is internal. So we will internally assess the case and ensure that it on the basis of the information that we're provided with, it fits within the parameters of our funding criteria in terms of the budget and the quantum, the ratio between the two, and the likely chances of success on merits and jurisdiction and path to enforcement and recoverability. If we are satisfied internally that this is a case which is likely to fit within fit the criteria that we're looking for, we will then enter into a term sheet with the client with a period of exclusivity. And during this period of exclusivity, we will conduct a second level review using external counsel this time and an external quantum expert, and where necessary, industry expert as well. And if the external counsel comes back and confirms that the case does indeed have at least 60% chances of success on jurisdiction and merits, and the quantum expert confirms the minimum quantum that we're looking to find, We will then bring the case up to the investment committee, which is tasked with reviewing cases and approving them for financing. And we will also negotiate a funding agreement, which we once entered into, the case is funded.
How do you see third-party funding developing in the next 5 years? What impact do you expect the pandemic will have?
I expect that the significant rise and evolution of third-party funding that we have seen over the past few years will continue, both in terms of geography and users and types of cases funded. And in terms of the pandemic, as with any liquidity crisis, I will expect that recourse to third-party funding will increase, both because of the increase of disputes which will arise as an outfall of the pandemic, and because of the financial pressures faced by businesses, both as a result of the pandemic directly and as a result of the governmental measures taken to mitigate the effects of the pandemic.
What happens if there is a disagreement in case strategy?
That it depends on the internal policy of the funder. At Vannin, because we adhere to the Code of Conduct of Association of Litigation Funders, we do not have control over the case strategy. So the case and the case strategy belongs to the client and the client's legal counsel. If a decision is taken which we believe lowers the chances of success to below 50%, we will then return to our external counsel, the one who we consulted at our level 2 review stage, and we will ask for an updated opinion. And if the counsel comes back and says that due to the decision being taken, the chances of success do fall below 50%, then we can step out. That being said, even if we do choose to step out, the client still has the possibility of challenging the termination before arbitration.
What are the specificities, if any, in the Eastern European region?
Well, that depends on how you define the Eastern European region, but 2 points that come to mind is you have countries in the region who trade in natural resources outside of the region. From a funder's point of view, that's a very positive factor. It increases our comfort in terms of enforcement and recoverability. And another thing to keep in mind, also from the point of view of enforcement, is to the extent that any country is also an EU member state, what impact will a Khmer type and illegal state aid issues have?
And now several quick questions. What advice do you have for claimants or companies seeking financing for their disputes?
To provide the most comprehensive set of documentation as possible. The more comprehensive the information provided, the more chances you have of piquing a funder's interest and ultimately securing a favorable financing decision.
How many cases obtain funding?
About a handful.
How do you price your return?
So at Vannin, we're not constrained by a rigid investment mandate, and that enables us to offer tailored solutions which are tailored to each specific case and take into account the specificities, for example, discounts for early settlements or increase in multiple past a normally expected payment date. Similarly, or a decrease in the percentage of damages as the quantum increases, so we will not be asking for the same percentage of damages for a quantum of 5 million as for a quantum of $5 billion.
What is a funder's role during the life of a funded case?
During the arbitration, we conduct key stage reviews and we monitor the case. We ask to be provided with brief monthly updates as the case progresses. And if and when our input is solicited, we're able to and very happy to provide it. But as mentioned before, the case and the strategy belongs to the client. So we will only give an opinion if asked to do so.
How does one ensure the protection of privilege and confidentiality when communicating with a third-party funding?
So as you know, issues of privilege vary by jurisdiction. So whether privilege attaches to the document, whether privilege belongs to the client, whether it belongs to the lawyer who can waive it, whether, as in the context of France, whether it's an obligation and a duty and a right of the lawyer, so not able to be waived by the client. And so in order to avoid any pitfalls of privilege and ensure the confidentiality of exchanges, we enter into a non-disclosure agreement as soon as we're approached with an opportunity. And if and when, in certain circumstances, heightened confidentiality assurances are required, we can enter into a confidentiality agreement subsequently as well.
What is the main obstacle for a greater use of third-party funding worldwide?
Preconceived notions, and with the adoption of pro-third-party funding legislation, with the acknowledgement of third-party funders as actors in the dispute resolution process, with the removal of historical barriers, and with the understanding and internalization by clients of the various benefits of third-party funding, we can expect to see a continued use of a continued increase in the use of third-party funding worldwide.
Do you think artificial intelligence could change the decision-making process in third-party funding?
Yes, I think so. As with the decision-making, any decision-making in the dispute resolution process, I think that AI will provide funders with an additional tool to better assess the merits of an opportunity, to better assess the risks associated with an opportunity and the value of the quantum, and at the very least will enable funders to reach decisions quicker.
Do states and state entities use third-party funding?
Yes, they do. For example, in Phillips v. Morris v. Uruguay was funded. One can imagine where the state has a counterclaim or where the state is trying to enforce a favorable award.
Can the costs of funding be recovered?
Yes, they can, in circumstances where the claimant is impecunious, where the claimant's impecuniosity was caused by the respondent's conduct, putting the claimant in a situation where it had no choice but to resort to funding, where the funding is disclosed at the outset and the cost of funding is reasonable. So the seminal case on this is the SRV Northcott case, where the arbitrator found and the English High Court agreed that the claimant could recover its cost of funding.
What is the biggest difference from work as counsel and international arbitration?
It's the point of view that one adopts. So as counsel, what one is most concerned with, or at least what I was most concerned with, is the zealous pursuit of your client's case, the zealous defense of your client's positions. Whereas as a funder, what you're most concerned with is the timing and extent of recovery.
What do you like most of all in your profession?
Being at the forefront of a quickly developing industry and the combination of the very commercial, practical, and pragmatic point of view of an investor, combined with the analysis of complex legal issues which are inherent in high-value international disputes.
And last but not least, I understand that you are multilingual. For our Russian-speaking audience, are you able to consider and assess investment opportunities in Russian?
Yes, absolutely.
Thank you very much.
Thank you very much, Olena, and thank you very much to the EEDRF.
Thank you.